A very good evening. My name is Orgo Sengupta, and I'm the Research Director at the Vidhi Center. Thanks very much for joining us for the second edition of the Vidhi Dialogues. We're delighted today to have two incredibly talented panelists to speak about the economic survey and the union budget. We have Dr. Arvind Subramanian and Mr. Arvind Datar. True to what we do with the Vidhi Dialogues, we try to get an economist, a social scientist, together with a lawyer to try and discuss issues of contemporary significance. And we felt that in the month of February in Delhi, there is really no other topic to discuss other than the economic survey and the budget. At the same time, this is not really a subject in the sense that it's rather vast and capacious. So we've decided that our primary focus today will be on trade and commerce in the Constitution of India and what the economic survey says about the trade and commerce in the Constitution of India. Now, as you all know, the fact is that in Article 301 of the Constitution, we make a solemn declaration that trade, commerce, and intercourse in India shall be free. At the same time, because we have a federal structure in the Constitution, we've made leeway for states to impose restrictions both in public interest and as well as non-discriminatory taxes. And for the lawyers amongst you, as in the Supreme Court has recently given its judgment in Jindal's case, where it on the issue of entry taxes, which has allowed states to impose entry taxes as long as they are non-discriminatory in nature. So again, widening the ambit of what can be done by states. So what does that do to the economic union of India? What does that do to that solemn proclamation that we made that India is to be a common market? Now this has, obviously it has economic implications. And Chapter 11 of the economic survey talks about it, and Arvind is here as the lead author of the economic survey to look at the economic implications of the trade and commerce provisions in the Constitution and how we can think about moving towards, if I may use the words, a more perfect union. And at the same time, it raises several legal questions about the federal nature of the Constitution. Mr. Datar was there arguing. In the end, what we'll follow is that there will be opening remarks from the speakers for about 10 to 12 to 15 minutes each, and then we'll have a moderated discussion on the issue, and then we will take questions from the floor. So first, I'd like to hand over to Dr. Arvind Subramanian. Neither of our speakers require any introduction, but Arvind is the Chief Economic Advisor to the Government of India, he's been an economist at the International Monetary Fund, a professor at the Harvard Kennedy School, and at Johns Hopkins University. He's also been rated by Foreign Policy magazine as one of the leading thinkers in the world and has a number of publications to his credit, and a well-known expert on India and China. My personal highlight is the fact that he's made the economic survey not only readable in substance but also in form. So thank you very much, Arvind, for coming today. Mr. Datar is a senior advocate of the Supreme Court of India, and he's an inspiration to us younger lawyers because not only is he constantly appearing in the leading cases, be it the entry tax judgment or the Sahara case, where he represented SEBI, but he's also a prolific writer, and he's authored treatises on the Constitution of India, on central excise law, and writes frequently for the press as well. So, Mr. Datar, thank you very much for joining us today. So with that, I'll hand over to the speakers. 10 to 12 minutes of opening remarks. Arvind, thanks very much.
I should try and get the Bengali accent right in Orgyo. Thank you, Orgyo, I should say. But I can't do it.
Well tried.
It's a great pleasure to be here. And it's also great to see so many, young, faces in the audience. Let me start with a small personal aside. When I finished my PhD, I kind of wondered whether I should join academia, and I thought I was basically just too mediocre to be an academic. So I went running away to an international institution, and I worked for what was then called the GATT, the General Agreement on Tariffs and Trade, which is now the World Trade Organization. And I actually spent 4 years learning a lot about international trade law. And I must say that I found that really exciting, and I really learned a lot. And then, of course, I went on to become a more boring, hardcore economist. But in some sense, it's that background that I think has led to something that we've done in the survey, which I want to get to next. So, I've been here about 2.5 years. In the first survey, we discussed the whole APMCs and the restrictions on agricultural markets. In the second survey, we did something on the power sector, and then I worked on the GST. And then these were 3 just fantastic examples which brought home to me that, something is not right with India as a union. APMCs, not just states can impose restrictions, but within states, you can't get free movement of agricultural products. So forget about free interstate movement. Power, I cannot tell you how much it bothers me that, one state today can say that if you get power from another state, you will have to pay an extra tax. There's what's called a cross-state surcharge. The GST, as we know, well, hopefully it will change everything, but, we had all these entry taxes, which essentially, impeded movements of good across states. So we were planning to do something on the economic side of One India, and I'll just talk about that in just a moment. But it struck me that, we're focusing on the economic side, but what about the legal constitutional side? And I don't know at all Indian legal law, constitutional law, but it did strike me that maybe these things should go together. So then, of course, I got in touch with Orgyo. I had discussions with one of our preeminent constitutional experts, which is the finance minister, and said, we're going to be doing this, and so kind of brainstormed a little with them, and they've contributed enormously to this chapter in the survey. So in the economic survey, there are 2 chapters on the greater economic integration of India. This is actually, I don't want to sound, this is not, my team did all the work. So on their behalf, I want to be a little bit immodest, because we actually used big data for the first time, and we have the first estimates of trade within India. You find such data for the US, for Canada, for Brazil and China, but no one had ever produced this for within India. And thanks to the GSTN, which made available transactions level data, my team was able to come up with trade, how much trade takes place within India. Similarly, we got hold, thanks to the railway minister and thing, we got hold of this incredible data source, which is from the railways. Every passenger movement between every origin station and every destination station in India for the last we can go back 25 years. Now, when we put together both these sources of data, we found something incredibly exciting and something that completely countered to our intuition. And indeed, the caricature, on trade, the caricature is, we even have a picture in the survey of, trucks at borders trying to get through. And the caricature is, and The Economist magazine often refers to this, it's in India where you have to pay bribes to get across, so, trade within India is very difficult. But the numbers we got were astonishing. Within India, trade is about 50% of GDP, which is actually almost slightly greater than how much India trades with the rest of the world. And it's much greater than how many other countries or big federal polities trade within each other. Take the European Union, for example. They have the 4 freedoms of movement. And you see that trade between the member states is much lower than that within India. So India does very respectably on trade in goods. Similarly, on people flows, the abiding image in my mind, which someone told me, was on New Year's Day in China, about 280 million people board the train to go back to their villages. So it's a kind of economy on the move where a lot of migration takes place. When we put together the railways data, we found that, actually estimates of migration that we've come up with are twice what people have thought, the amount of migration within India. The census-based estimate is something like 3-4 million people moving every year for work, but we find something like 9 million people in the last 5 years. So it's really an India on the move. There's a lot of churn taking place within India, and it's very encouraging because, all of us, we know that, at a time when internationally, integration is being repudiated. Within India, internal integration at least, it seems to be proceeding quite rapidly, which is really good news for India, because all the gains that we know, the efficiency gains that we know come from integration of markets, seems to be happening endogenously through movement of trade and people. But then the question, and this is where I kind of want to say a few words and then pass on to the experts. Then I said, but where does how does the Constitution kind of speak to this issue of integration? And this is where my kind of trade background came in. So what I thought was, okay, what are the other federal polities? How do they deal with this? In the US, you have the famous Interstate Commerce Clause, which basically the default is free movement of goods within the US, except for some very narrowly prescribed restrictions. You take the European Union, so if you kind of invoke the US, you have to understand, I'm kind of getting into the Indian collective psyche as well. If you say the US does this, no, but US, older democracy, richer country, this doesn't, India is unique, doesn't apply to India, all those arguments come in. Then you take the European Union, which is, it's really, in terms of political integration, is way behind India in many ways. In fact, the chapter in the survey begins with my kind of, evoking when Raj Kapoor says, "Fir bhi dil hai Hindustani." It's kind of politically and in terms of consciousness, we are kind of one, but you look at the legal provisions within the European Union, the four freedoms basically, again, go very far in ensuring that movement of capital, goods, services, and people. Of course, the people part of it is what is now leading to the backlash within Europe, but we can talk about that to some extent. But Europe is well advanced. So, but then what struck me was that if you even compare the Indian Constitution with the WTO, where, remember, the WTO is a model of economic integration between countries who don't even aspire to be one politically. It's completely different. You have a Burundi and the United States, and yet they adhere to rules for free movement, which to me seemed much more permissive than the Indian Constitution. For example, there are lots of lawyers here, but I don't want to bore you with it. For example, in WTO law, I know this because I once upon a time used to deal with this and I follow this, that if you impose any restrictions that violate national treatment or the most favored nation treatment within the WTO, there are some very stringent standards that you have to pass before it can be deemed to be legal or compatible with WTO law. But if you look at the provisions in the Constitution, it's basically, and then, of course, Orgio and the FM, educated me a bit on the jurisprudence, which, of course, obviously I know very little about, and I'm really very keen to hear what others have to say. But if you look at the constitutional law and jurisprudence, you say, wow, we're not even close to the WTO in terms of providing, free movement of goods and people within the country. So I end up, obviously, economists and government economists can't, question the Constitution. It's none of my business. But the thought, I want to end up with is, in fact, economic integration is proceeding very rapidly. And, whatever the early imperatives might have been to be permissive and give states the sovereignty to kind of do what they wanted to, even if it meant restricting movement of goods. We've come a long way since then. Nobody takes our political integration. It's never in doubt. Nobody, Phir bhi dil hai Hindustani, we're all Indians in some sense. There's no kind of doubts about whether, oh my God, we'll fragment politically. So if we are so ahead politically in terms of our sense of a nation, sense of a polity, and given, the GST has unleashed this spirit of cooperative federalism, which, by the way, I think is, I've been so impressed with meetings in the GST Council at both the quality and the bipartisan nature of the discussion. So if we are in that mode, then perhaps the Constitution should kind of catch up with the economics and, be a little bit, favor at the margin, integration over, granting sovereignty that often leads to a lot of restrictions on Indian internal integration, as it were. So I'll stop there, and provocatively we end by saying, the Constitution lags behind technology and economics. Is it time for the Constitution to catch up?
Well, I think, of course, that's a provocative note to end with. And perhaps maybe the question is that, is it time for economics to comply with the Constitution, perhaps? I don't know what, Mr. Datar, you have to say, especially given the fact that the entry tax judgment that is given by the Supreme Court as an allows states wide leeway, and in order to impose such taxes, as in if it is non-discriminatory in nature. And we, of course, have 304B, which allows restrictions in public interest, and that public interest is very loosely defined, something that Arvind was alluding to, even if you compare it to the WTO. So I hand over to Mr. Datar for a constitutional history of Part 13, and how you see it evolving, and perhaps especially given the fact that there is a strong move towards economic integration in India being desirable.
Yeah. Good evening to all of you. I'll try to be as less legal as possible, so to make it more appreciable to a general audience. Well, we had this Part 13 of the Constitution, which came up before 9 judges. And in fact, those who, if you like, small statistics, this is the 16th time that 9 judges of the Supreme Court assembled to decide a case in our history. And you can basically say what is a position pre-11 December and post-11 December, because that's defining the entry tax judgment as very, very far-reaching consequences, which we will come to know in the years ahead. But just a very, very brief background. You see, Part 13 of our Constitution is basically the origin in the Government of India Act. They found that in many cases, particularly the princely states and so on, there used to be tariff barriers. They would impose strong taxes to prevent goods from other people coming in. And so for the first time in old Section 297, they said that, look, between provinces, you can't have one province levying heavy tax on goods from outside the state, outside that province, and lesser tax in that province. So for example, if this cell phone is made in Tamil Nadu, I can't say cell phone made in Maharashtra will suffer 14% tax and cell phones in Tamil Nadu will suffer for 7% tax. That is simply not allowed. Then when the Constitution came, and though Part 13 is just basically 5 or 6 articles, the debates are very, very interesting and very humorous indeed. In fact, Dr. Deshmukh criticizes the whole thing. I don't know if you've read Dr. Deshmukh. He said that this is the most complicated piece of legislation. It's going to be a lawyer's paradise. And he said, what are you saying? You start with a section saying that trade, commerce and intercourse shall be free throughout the country. Right. And then you say, but Parliament shall not do this, but the state shall not do this, but you will not do this, you will not. So it's followed by notwithstanding proviso, notwithstanding proviso, correct, notwithstanding proviso. Correct. So it's like saying that, look, you're a man, Dr. Deshmukh says you're a man, and you're wearing a dhoti, but notwithstanding you're wearing a dhoti, you'll be treated as a woman. And notwithstanding a woman, that dhoti will not be treated as a sari. Yeah. So it makes a very humorous thing and tears this particular part to pieces. And you see, the origin of 301 is basically Section 92 of the Australian Constitution, which says that trade, commerce shall be absolutely free. And that absolutely free had created a lot of problems in Australia. So when we drafted it, we dropped the word absolutely and we said that subject to the provisions of this part, trade, commerce and intercourse shall be free throughout the territory of India. So if you see, basically if you just stop with Section 301, then the Constitution is completely free. Trade, commerce should be free throughout the territory of India. But then you always have, this is just a very idealistic concept, you have certain exceptions. And very briefly, I'll tell you what the points are. One, Parliament cannot discriminate between states. It can't say that the tax paid by X state will be less and the tax paid by Y state will be more. So there has to be equality of treatment to all the states.
It's what we call MFN in most favored nation in trade law.
Trade law, but I don't know MFN, but what they say that Parliament cannot discriminate, because see, you may have a system where you may have a ruling party in the center, yeah, exactly, and just to get at the opposition parties in the states, it may try to make some hostile discrimination, which is constitutionally prohibited. That's first part. Secondly, the state governments also can't make laws which are discriminatory against each other. That's the other part. Now, the whole debate in the 9-judge bench, why did it go to 9 judges? It was because of this concept of compensatory taxes. And compensatory tax means a tax to compensate the building of infrastructure and so on and so forth. In my opinion, compensatory tax is basically a contradiction in terms. All taxes are meant to provide services and utilities for people. And I did a bit of a history into the subject. In fact, in the Oxford History of the Constitution book, I have contributed to this chapter, and I had the opportunity of going in. Where did this all start? It all started with some jute moving down the river from Assam into the Hooghly into Calcutta. And it's astonishing that all the tax was 3 pies, P-I-E-S, which was in those days, per mound, M-A-U-N-D, which are all old things, we've all forgotten it. A very minuscule tax was supposed to be paid on tea and jute floating down the river. Now the simple question was, does this restrict trade and commerce? And to my mind, it was very simple, no. We'll have to see that, look, if I impose tax of 5 rupees, will it impede the flow of this phone from Assam to Calcutta? Will it become a trade barrier? Will it become a tariff wall which will prevent the movement of goods? But instead of doing that, with great respect to the Supreme Court in those days, they said, no, you're not got presidential assent, they simply struck it down. There's not a single discussion, what is the quantum of tax? If I put 5 rupees in those days, or say 5,000 rupees for per kilo of thing moving from Assam to Bengal, if Bengal imposes the tax, you can say it's discriminatory, but otherwise no. That said that yes, the tax is bad. Now, once you say that any tax on movement of good is bad, it created chaos, because it would have defeated the state's powers to tax. So it was referred from 5 judges to 7 judges, which is the next case is called the first case is Atiabari, which is the Assam case. The second case is automobile transport, which again, in my opinion, was not really necessary. If you see automobile transport, what happened? A Rajasthan law said that cars will pay X rupees of tax. Something came to some 5 rupees per car per month, it came to about 60 odd rupees. And for trucks and commercial vehicles, it was based on the quantum of weight it could carry. If it's a 12-ton truck, it will pay so much of tax. There is a specific finding by the full bench of the Rajasthan High Court that this does not affect trade and commerce. But that was taken to the Supreme Court, and Supreme Court evolved this concept of compensatory taxes, which after 1963 till 2017 created havoc, in the sense that what is compensatory? So states started levying taxes which could not be justified, but they were justified on the ground that I am collecting money, but I am building a road, I am building a stadium, I am building schools and so on and so forth. That's how it went on. Now there were some subsidiary issues which is important in the context of what Dr. Subramanian mentioned. We are talking of the intention is to promote movement of goods, that as far as possible it should be economic integration. The movement should be to the bare minimum. Taxes, you pay some taxes, but as little as possible. What happened was, he mentioned about the long queues in Octroi and so on, and all of us know that Octroi was an absolute miserable piece of duty, and there was enormous amount of corruption. In fact, in one lecture of Mr. Palkhiwala, which he came to Madras, there was if all of you don't know, the richest municipality in India is the Pimpri Chinchwad municipality in Pune, where also maximum amount of Octroi is collected there. And it so happened that the staff of the Octroi went on strike. We call it Naka, Octroi Naka. It went on strike. So what the government did was, they said the Octroi was on strike, but they told those trucks passing by, on your own you pay what you want as Octroi. And it so happened the collection was much more when the people were on strike than otherwise. So you could imagine and it's a fact, so you could imagine the kind of leakage or corruption that was taking place. So what the state said was, look, this Octroi is a problem. It creates bottlenecks, this corruption. We'll simply abolish Octroi. What we'll do is we'll put entry tax into the state. If the goods come into Tamil Nadu, because the constitution says you can levy entry tax only on entry into local areas. Local area means a municipality. Now every state is an aggregation of all municipalities. So if I enter Maharashtra, I'm entering to some local area. So they say if you enter Maharashtra, you pay entry tax. Now the consequence was, if I bring the goods from Karnataka into Maharashtra, I pay entry tax. But if the goods move from Pune to Sholapur or Pune to Bombay, there is no entry tax. So there is straight away a discrimination. So this was the consequence. Now to cut a long story short, ultimately what has the 9-judge bench held? Now this is the important point. First, they have said, in my opinion wrongly, with all due respect, the constitution says trade, commerce, intercourse shall be free throughout the territory of India. Secondly, they say Parliament and the state shall not make any laws which discriminate. Now, what is the meaning of laws? I argued that laws can be tax laws, other laws also. The Supreme Court has said no, laws will not include tax laws. So for all of us hereafter, In terms of Part 13, the state can levy any tax it likes. All it has to do is to ensure that it does not discriminate between local goods and other goods. Otherwise, any tax can be levied. Our argument was, tax laws is just not the rate of tax. It's not just not 15% tax. I can say Maharashtra goods will be subject to extra checks and balances, extra procedures. I can have other discriminations. That they have rejected. On that point, we lost. So Supreme Court has said there is no concept of compensatory tax. You can levy whatever tax you like. They have said that the states are completely plenary, they are sovereign, and they've used Dr. Babasaheb Ambedkar's theory. When we talk of federalism, what is India's federalism? So the Constituent Assembly, Dr. Ambedkar said there is a partition, so to speak, between power to the center and power to the state so far as taxation is concerned. So we have partitioned the power. Some powers are given to the center, some powers are given to the state. And it is further said, a state is not an appendage of the central government. Each state is sovereign in its own right. So this is what they have said. So the point which have been left unsaid are two issues which are now going to be argued on the 8th of March before the smaller bench. The main issue to be argued is, can a state government make the entire state as a local area? Our point is, when you say local area, you mean a municipality. This local area law is a legacy of the Government of India Act 1935, and it goes up to 1919. All was intended to levy octroi. Octroi is now called entry tax. There is no octroi into the state, octroi only into the municipality. The other important issue, which is again have very, very far-reaching consequences, is I import the goods. I import goods into, let's say, Paradip port. Now there is no dispute that the moment you import goods, you pay customs duty under entry 83 of list on the Constitution. Now some governments have said, fine, you are coming into India, welcome, but you are also entering the local area of Paradip, so you pay entry tax on that also. So our argument is, just Bhanumati's negative, that was the argument I took, which has been rejected by her. She said, it is India, it is also a local area, therefore both can levy tax. According to our submissions, I don't know what the 3-judge bench will do. According to our submissions, when it first comes into India, only customs duty can be paid. Only when it subsequently moves into the Indian landmass, becomes part of Indian goods, can entry tax be levied. So that's a major issue which is of concern. The other point which again the Supreme Court has upheld is, states like MF and Dr. Subramanian mentioned, not more, I favor myself. Like what Punjab does is, it says that electronic goods, if made in Punjab, will suffer 1% duty, but electronic goods if made from other states will suffer 10% duty. And this was done for a 5-year period. Now this was done in video electronics, upheld. But in Mahavir Oils, the Supreme Court said no. The Supreme Court said no. If you can't have units in Jammu and Kashmir having a favored tax status, outside goods not having, so they struck it down. So there are two conflicting views. Now the law for all our information is, let us say you got the state of, say, Chhattisgarh. It can say that goods made in Chhattisgarh will suffer 4% tax, but goods made outside will suffer 10% tax. That is valid, provided it is specially tailored to the needs of that economic backwardness of that particular state. So Supreme Court says some states are very backward, some states are very progressive. I thought that is common sense. I mean, throughout the world, all over the world, there will be some states will be very progressive, some will not be progressive. That's even in the US, the same thing is there. The New York will be far more prosperous than, say, a Midwest state. But now, this is the dangerous part, in my opinion, where Supreme Court has said you can do it for a limited period. Now, what is limited? What is that? In fact, we argued the point was that there was a very famous chappal case, why it is called chappal case was, they said that chappals made without the aid of power will suffer 3% tax. It didn't matter whether chappals are made in Maharashtra, this thing. So our point was, you want to say that a newly started unit, a startup, will suffer 5% tax in Punjab, fine, no problems. But then say that any newly startup in India must get the same treatment. That has been rejected. So now the only issues left open for the for consideration is whether entire state can be a local area, whether at the time of import you can levy customs duty and entry tax. You see, because look at the consequence. Just imagine the amount collected by, say, Bombay, Madras, Cochin, which have got entry ports and others don't have. Right? Now, what are the consequences? Now, this is the law of the land from 11th of December. What is the consequence further? Now they have said that the states are absolutely sovereign in their own right, they can levy all the tax. My great concern in the GST is, under Article 246A, Parliament and states can levy Goods and Service Tax Act. One irony in the Constitution is, you have taxable entries for everything except GST. You have tax for octroi, you have tax for this, but there is no entry for GST. I don't know why. It should have been put in list 3, but it's not been put. Doesn't matter. Now, if you say that each state is sovereign and Supreme Court says each state is powers of plenary, under Article 246A, nothing prevents a state, a maverick state, from saying that, look, I've got tsunami in my state, I've got 20,000 reasons to support something. And lawyers will always add that 5,000 reasons more, so that's not a problem. So, suppose a state comes and says that, look, you levy GST, and now the rates are 0%, I think 5%, 12%, 18%, 28%. State says, no, apart from 28, I will put some tsunami surcharge, or I'll put some Jallikattu surcharge, something I'll put, and I'll add the thing because it's some problem peculiar to my state. There's nothing the GST Council can do. Under Article 279A, the GST Council's powers are recommendatory, and with 246A, it will be a big question mark whether we are going to have an integration or no integration. But Dr. Subramanian says that he feels upbeat about the interaction of the council. I think, like the thing, we must have some kind of a statewide GATT, where all states agree that, look, we will not levy tax more than this, we will not levy a surcharge. Some kind of self-discipline has to be levied. But right now, there is nothing in the constitution that will prevent a state from pulling completely apart and going on its own way. Because we have seen this, because history tells us you first have a tax, then you have a surcharge, then you have a cess. If you just go to the restaurant, just see your bill. It'll say VAT, service tax, Bharat cess, this cess, that cess, that cess, and then you finally get the bill. Sometimes the menu is small and the tax is so long.
That's true. Can I?
Yeah, sure.
Doctor, that's really wonderful, very illuminating. But actually, it's giving me the chills even more. And I'll tell you, and I'll explain, just give you 2-3 things. And I'll come to a provocative solution. You have this thing about, state GATT. It's a great idea, but let me give you a more provocative possibility, and I hope no one will tweet it. So the first thing, just observation I want to make is that if, for example, that Paradip port can impose an entry cess or whatever it is.
Entry tax.
I mean, this could violate our international obligations under WTO, because under the WTO, for example, if you say, here's the thing, right? So in the WTO, we bind our tariffs, and you negotiate that and you bind them. But there's another provision called Article 21A, which says any other duties and charges on imports, it's called ODCs, are frozen at the level in 1994. So if anyone imposes anything additional to that, it's simply WTO inconsistent.
Thanks for I'll use it on 8th of March.
Yeah. So in fact, this is in the Uruguay round, the first thing I was involved in is this Article 21A called other duties and charges. So I find it completely surprising that this is not a consideration that
no one thought of this.
Okay, but it's a very important point. The second thing is that the backwardness, and all those kinds of things. You see, I think here, I do think that there's a kind of need for, a kind of legal perspective and an economic perspective to come together. See, in the following sense, why is it, as you rightly said, in the United States, there's a very poor part and a very rich part. They say you shouldn't nevertheless impose this for backwardness or tsunami or whatever. The reason is that from an economist's point of view, if you have an objective like backwardness, there are better instruments for achieving that. And essentially those instruments, everywhere in the world, but we have them in India, is through resource transfers via finance commissions, plans, etc., etc. So in a sense, the economist's perspective is essentially that you are using a highly inefficient instrument to achieve an objective. And so in all jurisdictions around the world and in the WTO, whatever, what you say is that, okay, you have a social objective like backwardness, but you also have an efficiency objective, which is integration. The way to think about this is, what is the best way of you reaching that? And then what you generally say is that if you want to achieve backwardness, you have to do it through fiscal transfers. And essentially, when the Finance Commission says, they have criteria, says, our allocation between states will depend 20% on per capita GDP or revenue, that's precisely addressing that, backwardness objective. So to have the Supreme Court sanction a highly inefficient instrument to achieve an objective, it kind of goes against how the overall structure is set up, which is that finance commissions and so on. So I find that actually somewhat again disturbing and surprising.
If I may just interrupt for a minute,
yeah,
on this question of one state imposing a lesser tax on its own. In the Constituent Assembly debates, there was a mention that India is highly unequal. That is, by the time they knew that India is going to get together with the princely states and so on. And there's huge disparity between, say, what's happening in the Bombay presidency and, let's say, in the internal presidencies. Despite that, I think Sir Aladi and TTK, they expressly said, let us not give the states the power to have such discriminatory. Despite that, the Supreme Court has said you can do it. But they say, but of course, Supreme Court has tweaked it. They said it can be for a very limited period and must be very finely tailored to that state's requirement.
Yeah, and this is going to be my last point. So think of it this way, that if at the time of the Constitution, we were nervous about this, 75 years on, we have evolved other instruments for addressing this problem. And yet we have a kind of almost retrograde tendency to go back to that, which I find. See, the last point I would say, and this is where I think, if you look at WTO law and everything, okay, so supposing you say there are some situations where I do want to countenance this, then at least have some, in this case, of course, there are timing issues or whatever, right? But the way other jurisdictions look at this is that if it's absolutely, you have to impose this, then you subject to certain very stringent criteria. Is it the best instrument? Is it necessary to obtain the objective? Are you doing it in the least cost way? So I think our law and jurisprudence have to draw upon these things to actually build in these safeguards. And I find, therefore, the discussion a little bit almost crude in terms of not drawing upon what is out there in terms of really rich, because this is not new. I mean, the US, the EU, other jurisdictions, the WTO have grappled with this for decades now. And the jurisprudence is very sophisticated in this. So in a sense, I'm a bit disappointed that, we're kind of at a level of discussion here which almost is completely oblivious to, all these discussions where you can build in many of these, take account of these disparities, but do it in a much more calibrated and kind of nuanced fashion. And again, I come back to that point. In jurisdictions where political integration is not there, they make these fine calculations. But we are politically so integrated, So where's the kind of doubt on that? We should be much more advanced when we think about these economic integration issues than jurisdictions that are, still floundering politically.
Yeah, so I think the one question that comes up is that how is it that these economic arguments can come into the law? As in, that's essentially as in a
I forgot my controversial proposal.
I thought that was controversial enough.
No, I think maybe we need a kind of program for Supreme Court judges. Where we kind of expose them to all of these. I'm serious, but it's. I'm sure they're very. I don't want to. It's all this. No disrespect to anyone, but it's almost as if there is so much out there that maybe could be more.
Quite possible. Quite good suggestion, because I'm on a serious note. The Supreme Court judges, I think, go twice a year to Bhopal on a retreat, and they do invite different experts from various things. And maybe you can put forth this point that, look, see, for example, we argued this case for several days. None of us even thought about this WTO and that this is the issue. And like you said, other thing is our constitution says that courts should not get into policy issues. So if a particular state says this is my policy, now if in Tamil Nadu, suppose they say they are going to promote Tamil Nadu industries, I can't challenge it in Tamil Nadu itself. I can't challenge it in Maharashtra. They say out of jurisdiction. So there are so many issues. They say it's a policy issue. And now they have made it. You see, I don't know why they could have simply said no. My point is, if you want to promote, say, for example, the leather industry, let it be promoted throughout India.
Exactly, yeah.
Or you want to promote small startups or electronics, let it be electronics throughout India.
See, because it's fundamental to the notion of India as one union,
yes.
that you cannot favor, the leather industry in Tamil Nadu. That's what the union is about. But of course there can be exceptions to that. But they must be.
That's the problem.
Yeah.
What is the exception?
And
how do we tailor that exception?
Yeah.
So maybe one thing that we pick up from what Arvind has been saying, as in, is that when he talked about the fact that it has to be a necessary restriction, as in, can we think of some kind of a proportionality test, essentially, as in law, which is a concept well understood, as in by lawyers, that you may impose restrictions, but provided that those restrictions are not just narrowly tailored, one necessary to achieve a particular purpose. So first is necessity, and it's proportionate, so that there are no less onerous means of doing it than what you're doing. So do you think that and perhaps this is a bit of a contrarian perspective, but do you think that this proportionality analysis is the sort of thing that the majority judges were trying to do in the entry tax judgment?
Actually, when I saw this judgment, I was wondering how it's going to come into GST, because now GST has replaced sales tax for most states. You see, so there's no VAT anymore, there's a GST, except on a few items. So now I want to know that if this can be done, and suppose there's a GST rate of say 18% on certain goods. Now can one state say that, look, to promote my goods, I'm going to say that other states will have to pay this thing, or I'll give an exemption notification, though it's 18% under GST. Now you will say states are sovereign. I can do it. I can tweak it to my own requirement. That's a larger question that may come.
And here, my view is absolutely clear that certainly the law should not allow that. The constitution should allow that, and if at all that has to be allowed, it has to be because I think it's clear that if either in terms of raising rates or in terms of giving exemptions, the principle is that you cannot do that unless you have a GST council discussion.
Just like you rightly mentioned, economics side, the constitution is lagging behind, and politicians are even more behind.
Exactly.
So in that problem, they'll say, look, for my vote bank, I have to give this concession. So that's a point you must take with the GST council. How do you stop a state, because it's sovereign? Supreme Court has said they are sovereign, they are plenary in their own right.
But I will throw it back at you a little bit here. But if the constitution is going to permit these things, it makes the politician's job that much easier to invoke this.
Yeah, absolutely. Because the point is, I think that as in we are talking about power on one hand, and the politicians will always be looking at the question of whether they have power to do something. Yeah. Then there is the question of efficiency, and now that's always going to become a second order kind of question when you're talking about power. Mm-hmm. As in, so I think there's
because we have seen this in water, for example, because unfortunately, in this rivers, this is a perennial problem, particularly Tamil Nadu and Karnataka on water. You see, what do you do?
Yeah, and I think that this is a concern that cuts across many sectors, as in because you have the power to levy something, as in that it's not the most efficient way of doing it is not going to be the primary concern. I think we've had a terrific discussion so far, and I think it would be a good time to open it up to the floor, as in we have time for we have 25 minutes. So I only ask you to keep your questions short, one question, and please identify yourself. Maybe we'll take 2 or 3 questions together, and then and then go. Yeah, there's a question there.
Hi, I'm Karan Lahiri, I'm a lawyer. So this is my question. Mr. Datar would remember that one of the major concerns of the bench that was hearing it, especially 1 or 2 of the judges, was this issue of backwardness that came up. And I'm convinced that that if today you were to remove all of Part 13, retain only Article 301, which says free flow of trade and commerce, put in a clarification which says that this includes tax laws and all other laws, you would have a situation where states are challenging that amendment, saying that this goes contrary to federalism. Now, how do you bring in this is to both the panelists, more than a legal standard and having the court stand watchdog over this standard for integration, is there possibly an institutional mechanism which can be brought in to make states, especially backward states, feel that their interests will be taken care of, as opposed to a situation where you have a strong central government, another party in, let's say, a small backward state, and you have unfair conditions being imposed on those states. In fact, Mr. Datar would remember there was even talk about the fact that, the Finance Commission, there was a hiatus, and there was a discussion regarding Andhra Pradesh and Telangana as well. So how do you bring in an institutional mechanism that on one hand integrates, two insulates the decision making from judicial intervention. And number 3, gives comfort to backward states that regardless of the political situation, their interests will be taken care of.
Actually, you're right. I remember the debate because one thing was, see, it could not just be a backward state. As he put it, one question was asked by some judges is, now Telangana and Andhra have now split, okay? So Andhra Pradesh is just being formed. So you got this, so many incentives are being given and so on. So Andhra Pradesh will say that, look, I have to catch up with other states. So why can't I give tax holidays? I can say that whoever comes into the so-called new area of Andhra Pradesh, they will have no tax for the next 10 years, because why should anybody put up an industry? Because Hyderabad has gone to Telangana, so many industries have gone to Telangana. Now how do I get industries to be the industrialization of Andhra Pradesh? How can it get kick-started? So can I say that, look, for a period of 5 years, I'll have a moratorium. All those who come to Andhra will not have to pay any tax. That was a big issue. Now, according to me, as per the judgment, nothing prevents the Andhra Pradesh unless you can demonstrate that this 5% is finely tuned, it is mandatory to get the state going and so on. That's one particular issue. And I think perhaps the Supreme Court, instead of emphasizing on the strength of the center, it has given more power to the state. So there could be a more kind of a, instead of being, it's become like, can I use an analogy of physics, centrifugal, so to speak. States can pull away and say that, look, this is my power under 246, and GST is a big danger in GST in that.
So I have a couple of reactions to that, right? One is that, one, we do have, at least I can think of 2 mechanisms where that happens. One is the Finance Commission. I mean, it says explicitly backward states with weightage of this, less revenue this, and over time I think that's been increasing. So in that sense, you could argue that that's one mechanism. The other is, of course, used to happen in the old days under the Planning Commission. Plan transfers used the Gadgil formula, right? And in that too, you had backwardness as one of the criteria. So that's one. And of course now, the interstate council that we have, where discussions take place, and I think that could be another forum where this happens. But so that's one component of that. The other component is what Arvind, you said about the incentives in Telangana and all this. There, I have 2 answers. One is that this is a standard in all jurisdictions. We have the problem of race to the bottom. In the European Union, for example, if you relax, no country can have lower labor standards as a way of attracting investment. So they apply it not just to taxes, but also to labor standards, right? Now, my response to Andhra Pradesh would be, look, so race to the bottom cannot be a thing. So, however, if you still want to do it on taxes that are less likely to give rise to these race to the bottom. So, for example, if you want to give lower, incorporation fees, or give low, i.e. not on the GST and those taxes, but on the taxes that you control and that are, that affect interstate. So, for example, property tax. That's something that all stamp duty, states can do that. So you're welcome to go. But you should not, there should be, so this is again the kind of the proportionality and the least damaging thing that, yes, okay, we're a union, we can't have race to the bottom. However, under certain things you can, but the criterion that, do it for, after all, you're going to lose revenue, do it in terms of losing revenue where you inflict the least damage on the union as a whole. Property tax, stamp duties. So that would be my response to this question. And the law can build that in via the proportionality test, etc., etc.
And I think there is a third institutional way of doing this, which is that if you see, there is also the issue of backwardness within states. So the Constitution in Article 371 for the states of Maharashtra and Gujarat allow the president to authorize the governor to make special provisions for Saurashtra and Kutch in Gujarat and Vidarbha and Marathwada, I think, in Maharashtra. So there are institutional mechanisms which are possible which allow sort of non-judicial methods to mediate this question of backwardness without getting into some kind of doctrinal issue. We had a question at the back there and then one here. There was some, yeah. We'll take two.
I have a more general question. I wonder how much of this, as Dr. Subramanian said, is not only that the Constitution lacks the economic framework, but that the Constitution is in this domain at all, and that this particular part of the Constitution is overwritten, because these discourses and conversations are just, in my view, not meant to be conversations that can be had in the Supreme Court? Why can't these be through instruments of statutes and not in your meta document instilled as values that you have to adhere to, rather than left to the government of the day to sort of trade-offs between efficiency and how you address backwardness are such ideological issues that you can't have a constitutional position on them, and therefore why must they be resolved at the statutory level rather than be instilled in the meta document that's your constitution?
Should we take, because then we can get a few more in. Yeah, there's one here.
Hello. Yeah, thank you. I'm Shrija. I work with Mint. So my question could be seen as something of a follow-up from his, actually. But Mr. Datar was speaking about how there can be sort of a mismatch between the entry tax law and the GST, entry tax judgment and the GST. I'm wondering if there should be a law to actually harmonize the two, and so that the entry tax judgment effectively does not, it's to the panel. So if you think there should be a law that the parliament brings in now.
Sure, there's one at the back, and then we'll go to the panelists.
Sir, you see, when we talk about, harmonization and standardization, so there is apprehension that the advanced states, they can suffer. When we are trying to protect the interests of so-called backward states, so how to reconcile these, contradictory positions, that when we are trying to protect the interests of backward states, so at the same time, the advanced states, they have this apprehension that they will suffer in this process.
Okay.
Actually, that's actually an excellent point, which I should have made in response to the backwardness and race to the bottom. Remember that the ability to grant exemptions is more with the richer states than with the poorer states. So in fact, putting restrictions on that is actually a way of moving in a protecting the poorer states than in the other states. So I think that's a good perspective on that. So, I mean, after all, let's be, Gujarat used to give a lot of tax exemptions because it was a rich state, I mean, a state like Nagaland or Manipur have less ability to do this. So in a sense, by having these restrictions, we're making it pro-poor and pro-backward states than the other way around. On the question there, I'm surprised at the question because first example and then principle. The US Constitution has an interstate clause. The Treaty of Rome or the whatever says the four freedoms are sacrosanct. WTO law also enshrines these things. So I think there are some principles that are, after all, that's why we have a constitution, precisely because these are meta principles, i.e. that if you're a union, that we should have free movement of goods, etc., is a sacrosanct principle. Of course, you may want to have exceptions to that, which you can discuss, but I think it's so sacrosanct that we forget that I would think that it should be in the constitution, and whatever else you may want to do, you can kind of do that. Now, the question of the follow-up, there are two ways of doing what you're saying. One is to make the constitution bench, adapt to the GST, or the other is to get the GST to adapt to the constitution bench. And I leave it open to you as to which is the better way of going,
Yeah, I'll start with your question. I'll go in the same sequence. Now, my answer to that is, in fact, this is just more of a metaphorical debate. The constitution is behind or economics is behind. When constitution is made for 100 years, 200 years, so it's going to be like the Rock of Gibraltar, and it should be as amended as less frequently as possible. So the question is, should the constitution contain a provision, or should it be left to the states? What you're saying is, let the constitution not be concerned with these debates, let them be at the lower level. I think there's a danger to that, because as we argued there, ultimately, what is the goal? The goal is the economic prosperity. Each state wants to give possibly the best standard to its own people. Now, while doing that, how does it make its lives of their citizens or their people better than the others? They can do so by giving more, indulging in favoritism, saying that if you come to our state, I'll give you all these benefits to you. Now, the point is, the end is a better life, a better standard of living. What is the permissible means? The permissible means can't be discrimination between states. You can't achieve that end at the cost of enriching your state at the expense of the other. So what basically part 13 says is, trade commerce shall be free throughout India. And according to me, all this debate are unnecessary. So they asked us a question. Can you all say that trade commerce should be free? At what point of tax does a tax hinder trade? That's the question mark. Can you say 5% tax hinders, 10% hinders, 20%? What is the benchmark, right? So the point I had submitted, I took the benefit of competition law. I said, take the test of appreciable adverse effect on trade and commerce. Now, suppose, for example, there'll be a threshold point, a tipping point, so to speak, at which point of time it is going to hinder trade. But suppose I levy a very marginal tax on goods, it won't affect trade. No, elastic demand. No, one point I was making. Then the other point is, apart from interstate trade, why the importance of constitution? We argued that 304B, which doesn't talk of discrimination interstate, you could have trouble intrastate. Suppose, for example, a particular state imposes, now suppose I impose 200% duty on alcohol, nobody complains. But when I impose 100% duty on a life-saving drug, it will be struck down because it will be against public interest. So we said that taxes must be part of it. And I would say that it should be in the constitution and they must be disciplined, because unless there is some discipline, the states may go completely awry. Now coming to your question on this entry tax and GST, well, with all due respect to Dr. Subramanian, I've been writing against the GST for so long, and I always feel that a GST where there are 29 GSTs is basically a meta oxymoron, because you can't have a GST, must be only one GST, but that's the Indian version of it. So now when you have 29 GSTs, one CGST, one IGST, and then we say one state, one tax. Now, if this is the problem, now add to that, add the spice of state sovereignty, add the spice of state autonomy, and then what is going to come? So, it is very, very important what we're going to see now. Once GST comes and it goes along, unless there is some kind of mechanism where there will be something which are absolutely impermissible, you can't do it. This can't be done. And now to conclude with his point on exemptions, I don't know if it's because rich states can get exemptions. No, a state can become rich by giving exemptions. A poor state can become very rich by giving exemptions. And in fact, the paradox is that I don't know how 28% GST is going to be sustained by anybody. Like in Madras, we had this parking fee of 2 rupees. Then some wise person said, let's make parking fee of 10 rupees. The collection dropped by 80%. Because when you put more, people are just going to keep evaded. So I am saying that this rich state, poor state will not be there, because even if I am a rich state or a poor state, like say Andhra, starting all afresh. Now, as you rightly put it, they can give lower taxes. What they are doing, Andhra is doing, and every week industries are moving from Tamil Nadu to Andhra, is because all the clearances are quick. So they're giving administrative efficiency as an incentive, which can be done without resorting to it. That's perfectly fine. That's welcome. Welcome.
But there was one question which I had some concern about, because you said that when we think about, is this the percentage of tax that hinders trade or commerce?
I have an answer. I have a question. I wanted to respond.
Okay, I'll just finish the question. As in, I think we might be on the same point.
Because Justice Sinha in the 61 judgment said the taxes can't become a tariff wall. Now, when does it become a wall? When is it a hedge? When is it a...
No, and I think you may be on dangerous terrain here if you're looking at percentages. As you know, it's 4% a wall and 5% not a wall. As in, shouldn't there be more a principle of discrimination? As in, that's really the kind of principle that we are looking at. So what is discriminatory?
In fact, Arya made my point. So it's very simple. I mean, if you want to levy 5%, 20%, 30%, but the rule is you apply it on goods produced in your states, you apply it on goods coming from other states. That's the principle, non-discrimination. And that kind of solves the problem.
We've got some questions at the back first, there, at the back there, then one there. I'll take 3 more.
This is to the first speaker. You mentioned about the railway budget. Since 1924, this railway budget and the union budget, they are separate. And the reasons for those reasons still prevail. So why this is being separated this time, and it has any legal...
Not separate, unified this time.
Unified. So why it is done? It has any legal and policy implications? Okay, or it is just to make this government is different from others?
Okay, there's a question there, here and here. Can you go here? And then one mic to the gentleman in the back. Yeah.
Hi. My question is to Dr. Subramanian, because I come from economist background. So while we are talking about trade fairness and commerce and other things, and you mentioned about agriculture markets, and today you have e-markets for agriculture and farmers, there's a long-standing debate about the minimum support price. It's about whether the government should endorse it, because right now they do it for 23 crops. And it's some people and some economists have told that it kind of hinders the farmers to do well. But it's also like a safety net. So in this debate, when we are going on more of trade and other things and what can be done with agricultural markets and stuff, other things, there is a lot of mention in the economic survey, but I would like to know your views on the long-standing debate of endorsing minimum support price or not. And some people have told it should be for all the 26 crops, but then it becomes very difficult. So on that perspective, if you could give us a couple of...
Question at the back, and then we'll go here.
Good evening, everyone. I'm Abhijit. I'm a lawyer. I have a question for Dr. Subramanian. So this time, a significant amount of attention has been given to UBI in the economics survey. And even yesterday, Honorable Finance Minister was saying that we will be implementing it this year on an experimental basis. So, sir, do we have the financial power? Because till now, only developed countries have been successfully able to introduce a concept like universal basic income. So, what I'm trying to ask is, like, what new taxes from where will the revenue come to implement such a program? Thank you.
Okay, question UPI. Last one here.
There is an issue of origin state and destination state. There was also talk of 1% surcharge, right, when it comes to GST. There is an ambiguity related to that. I'd like you to put some light on that. Because it is an origin-based tax.
Okay, now we truly move from the economic survey to the budget here.
This is the kind of transition that I was dreading, actually. Sorry, you haven't finished your question.
Also, there is some contradiction when it comes to economic survey and when it comes to budget, right? You talk about there was unfinished agenda and all, but you talked about subsidies also. You talk about turbo fuels and all that, and agricultural subsidy, then taxing agricultural income also. But then we have the scenario, we have this state of the farmers, then we have the agenda of regional connectivity also. How to balance both of them? Your personal view.
Yeah.
Survey said that you should do that, but the reality says something else, right?
Now you've touched about 7-8 chapters in this survey. It'll take us the entire evening, and I think we should focus a lot more on the kinds of very interesting ideas that have been discussed and Arvind and Arge have been making. So I don't want to spend too much time on these issues. This is not about UBI and things. But on the first question, I think I think what you're referring to is the 2% central sales tax. That's going to be abolished under the GST. That's out. That was a clear interstate barrier. That's out, and that's been accepted, and it's a very desirable development because it was like an entry tax and so on. So that's very now. I don't have I don't think the railway budget merging this is the right forum to discuss this. I think the UBI. Enough has been said about it. I think it's a very interesting idea. It's a very important idea, but I think we need to discuss this much more. The Honourable Finance Minister has said, that this is something that we can try on an experimental basis. Let's see where the experiments come up. I think that, but this gets me to my broader point which you raised. Remember that I think the survey and the budget are kind of two distinct exercises and forums. The budget is something that you commit to, resources, policy, etc. But the survey has the luxury of also, throwing up ideas for discussion, which even if they're not immediately implemented, but it kind of permeates the ecosphere of ideas. Last year we had, the middle class subsidy, and I think it generated a good debate. This year we have some ideas on universal basic income, on the whole, public sector banks, how to deal with that. And also this, this whole discussion we're having today comes from the survey. And I'm very glad we're having this because, this is precisely the job. I think in democratic, polities such as India, I think that, how decisions get made are very complicated. The law is one part, the politics is one part, but the ideas and the ecosphere is another part. So I think all of these contribute to it, and I think that's what the survey tries to do, and hopefully it generates discussion. On the last point about MSP, I think the MSPs, let me say 2 or 3 things without getting into trouble, right? I think the MSP originally came into being because we had this big problem of lack of self-sufficiency in food grains, and we were trying to see what is the best way of overcoming that. we had the Green Revolution, but then in addition, we wanted to provide this, means for ensuring incentivizing production. And to be fair, like many things, it's been very successful. I mean, we no longer have the scarcity of food grains, cereals, etc. It's been very successful. But the problem with all these things is that, many of these policies, they work, but they should be kind of, they shouldn't remain forever.
Expiry date.
There must be an expiry date. Right? There must be an expiry date when it comes in. And obviously you can't do these things in advance, but you need a mature polity which can then discuss and say, what is it? Now, the problem is now that we have an MSP that works for the cereals, right? And so there's a big disparity in the way de facto policy favors some cereals and, in a sense, in a relative sense, doesn't favor others. So there are two ways to rectify that. One way is to, get rid of the MSP to neutralize the incentives across crops and provide these incentives through other means, technological research, etc., etc. But the politics is such that, in India, it's always difficult to get rid of or get expiry dates are very difficult. So what you actually then you do is then you kind of compensate by, introducing a new distortion. And essentially, I wrote a pulses report which said that if you're going to have MSPs for pulses, then, because we're in a pulses situation which is similar to the cereals, or we need to incentivize pulses, and therefore we need to, introduce MSPs. So it's a tricky question. I mean, after all, in some sense, you could argue that, our MSP's policy not only favors cereals, but de facto favors regions producing cereals. So it's kind of a regional disparity that comes about from this and kind of speaks to the question we were talking about. So if you want to have regional thing, then maybe, we have to either exit that or, do some other things instead.
We've got time for one last set of questions, but we'd request you to please keep it on topic if possible, because we've got a great panel and I know you might be tempted, but please try and keep it on topic if possible. One here, one here.
In advance if my questions amount to digressing. My first question is to Mr. Datar. Sir, while in your lecture in Nalsar University, when you were asked about the practical problems of GST, you had said that it can be corrected if it's done in a stage-by-stage basis. First, you do it implemented on 30 industries. So my question to that is, on what basis do you prioritize and say that these are the industries you want to try the GST on, then see the problems, and then kind of see what the solutions to those problems are? My second question is a bit structural. The RBI is vested with the responsibility to maintain fiscal and monetary discipline, which also includes public sector banks, where obviously the government is the majority shareholder. Section 8 of the RBI Act gives the power to the central government to appoint a governor. Section 11 also gives them the discretion to remove a governor before the 3-period prescribed tenure. So my question is, do you think such a conflict of interest can be corrected by a constitutional mention to the officer of the governor of the RBI?
Well, despite the digression, I'm delighted that we haven't come to demonetization yet.
but that's getting close.
We are coming perilously close now. So hopefully we'll stay away from that. There's one question there.
These are questions I'm going to leave to Arvind.
Dr. Arvind Subramanian, what about this anti-dumping tax of we are so many imported goods from China? How our protection will be there? It will be differential treatment in GST for them also?
Okay, and we'll take two more. There's one here, and there's one there. Yeah.
So, you were trying to impose international trade law on this is a basic question of sovereignty of the state, of an Indian state versus the sovereignty of a country. And I somehow can't, there should be a fundamental difference. I mean, there can't exist a Trump in India, in the sense of, somebody who wants to break out of that entire, what I'm trying to say is the constitution already takes care of, there not being too much of sovereignty inside the inside a particular.
Correct.
Yeah, so.
Get the point. Shreya?
As we're talking about economic integration and the laws moving towards recognizing that principle, what do you think is the way forward for the principle of fiscal federalism?
That's a very wide canvas.
You can take on fiscal federalism, Dr. Subramanian. Then I'll take the unpleasant questions.
Maybe you take the unpleasant ones first, and we'll end with an optimistic. First, let me take the unpleasant ones. And
I'll start off with your question, which I mentioned in Nalsa. Sorry, Dr. Subramanian, but I really don't very much like GST.
That's well known.
No, actually what I mentioned was, I said that, look, I'll tell you what my basic problem is, like demonetization you mentioned. Like H.L. Mencken said that for every complex problem, there is a solution which is simple, elegant and wrong. So my problem with demonetization was, maybe a good idea, but then what went wrong? A very big financial person from Calcutta told me, the simple problem was the ATMs were not software programmed to take 2,000 rupee notes. I don't know how far it's true. He said, if you had just demonetized and made different color 500 rupees and different color 1,000 rupee notes, there would be no problem. But when you introduced 2,000 rupee notes, there were no ATM could take the denomination of 2,000, and there's only one cartridge manufacturer in China, and that created the whole problem. So basically a good idea, but difficult to implement. Now, the reason why I mentioned GST, you see what's happening is, you're going to have 29 states with almost 500 million people migrating into the regime of GST. It's going to be a huge, a cataclysmic event, almost like what you call a black swan event. So I had suggested that, look, when MODVAT came in, when Dr. L.K. Jha recommended MODVAT, they didn't bring in MODVAT wholesale. They brought MODVAT at 37 items and then progressively. Now we don't know what's going to happen. Now just imagine if your threshold limit is 20 lakhs per year, everything is online. Now if you see the GST rules, you have to file. I spoke at the budget with Mr. Chidambaram on Saturday, and if you talk of GST, why I said this meal, what is the problem? Now, if suppose I'm running, say, a diagnostic center, or let's say a simple service center. Today I file 2 service tax returns per year, that's it. Now when I move to GST, I have to file 3 returns per month, so I have to file straight away 36 returns. On the 10th I file my input returns, on the 15th I file my output returns, and on the 20th I file my monthly returns. So 3 returns. Now just imagine millions of people going onto the portal on the 10th. Just imagine what's going to happen to the system. So 36 returns are straight away per month per trader, per year per trader. Then plus he has to file 12 returns on TDS, 48, and 1 annual return, 49. So from 2 returns you're going to go to 49 returns. This is the procedural complexity you're going to build up. And this is per state. Right? So suppose I've got diagnostic centers in 9 states, it's 9 into 49. So this is the complicated. So I said, instead of doing all this, try on an experimental basis, because you can't afford for the entire country to switch on 1st September and then face all these problems, because you're not tried it out. Right? This all, and often I find, all things in theory sometimes very badly failed in the reality. There's a lovely saying by Thomas Huxley. He says the beauty of science is that a beautiful hypothesis can be destroyed by a single ugly fact. So that is the thing on GST. And as far as RBI is concerned on fiscal...
there's an economist version to that.
Yes.
It may work in practice, but prove it to me it works in theory.
Yes. In fact, if you want, you read Simon Singh's Fermat's last theorem, where the theorem is, everybody knows it, but it took 12 years for Andrew Wiles to write the proof. Now coming back to this RBI thing, now the only way you can protect fiscal federalism is to make the governor of Reserve Bank like the Comptroller Auditor General of India. That once you appoint him, you can't remove him except by impeachment and so on and so on. So unless you have, say, part 20, say 16A, or have the 12th schedule, where you make sure that the RBI governor once appointed will not be removed for 5 years and so on. Unless that is done, it can't be done. So that's the point. And what was the other question?
Sub-state sovereignty. I think we've covered that issue.
Yes.
Sub-national sovereignty kind of.
Yes, but only thing I'll tell you what, Dr. Subramanian made a very interesting point. The economic salvation lies in not insisting on your sovereignty, but having cooperation rather than insisting on my pound of flesh. Anybody? What did you ask?
Fiscal federalism. It's a positive, pleasant question.
The last.
Pleasant.
I don't know. Okay, one, the anti-dumping point.
We can end on this hum sab Hindustani.
Anti-dumping, it has nothing to do with GST, because it's a border tax which we can impose. Nothing about the GST affects the anti-dumping at all. I would just want to say something in response to your question. I think that the broader point I was going to make, one of them, of course, is that, what Arvind just said. But I think that the broader point I was trying to make is that, you have this question of sovereignty that's being exercised by the states, right? But it has to be balanced with the larger notion of India as one union, right? Now, the puzzle for me is that in other contexts where the need to assert sovereignty is much greater, because you're very different countries, Burundi is going to say, I decide everything. But there, the rules for integration and economic union are much stronger. So we have to therefore try and bring that kind of thinking. And I do think that, that March, when you have this, seminar for this, I mean, can I invite myself for that? For that, I would love to, have this discussion with the Supreme Court judges. That's one. Now, on the last point about fiscal federalism, you see, this is what I want to say, that I do think that it's not a slogan, but I do believe that the future for India is cooperative and competitive federalism. I think competitive federalism kind of provides the dynamism that needs to be unleashed. I mean, Arvind gave a great example. If Andhra Pradesh can attract things by improving administrative efficiency, that's exactly the kind of competitive federalism we want. And if Gujarat attracted investment because of being this, but there are certain ways we must do this, and that's why competitive federalism has to be balanced by cooperative federalism. And we are now developing new institutions for cooperative federalism. The Niti Aayog is one such. We have the Finance Commission, and now we have the GST. And I want to end with this optimistic note, which is this: that I've attended almost all the meetings, even though I'm not an expert. I don't deal with any of these things in the kind of complexity that Arvind and the others deal with. But what has been really heartening for me to see in this is, first, the quality of discussion. It's really high class, high quality discussion. And I'm not spinning at all on behalf of anyone, because I have sat in, when I was at the WTO, at the GATT, I sat in on these intellectual property negotiations between the rich and the poor, and everyone was represented, widely divergent interests. And then we had what was simultaneously a technical process for everyone to understand each other's laws and how to move it forward, and an intensely political thing as well, because each country is trying to assert itself. So in the GST, it's very similar. After all, again, these are sovereign states. They are going to say, we have certain interests. But to see how the quality of discussion, and also quite often states not arguing their narrow positions and indeed thinking of something broader in the Indian good, I think it's just absolutely, it's not just encouraging, it's actually inspiring to watch this actually. And so I have great faith, notwithstanding Arvind's doubts about the GST, I have great faith that and this will be, but let's be serious. I mean, this is India, it's not, nothing is going to be perfect, nothing is going to be smooth. We're going to kind of, find our way through all this muddle and mess. But at the end of it, I'm very hopeful that we'll come out with really, competitive and cooperative federalism. Thank you.
Well, thanks very much. As in, we've had a session that was in equal measure cooperative and competitive. So maybe that is the future. So we've got a small token of our appreciation to our speakers. So please join me in thanking Dr. Subramanian and Mr. Datar. And thank you very much, ladies and gentlemen, for coming. As in, the Vidhi Dialogues will promise us to continue, and we please stay tuned to our various social media, whatever you call them, and please be in touch. Thanks very much for coming. Good night.